Good morning, Mr. Papadopoulos.
Good morning. How are you?
You may proceed.
First of all, I would like to thank you all on behalf of my client, granting my client the opportunity to submit this application for further appellate review on such an important issue as to whether or not the distinction between natural and unnatural accumulation of snow and ice should continue to be factors in determining whether a property owner has been negligent. The genesis of the law that has been in existence has been in the case of Woods versus Nomkeg steam cotton back in 1883, 120.
May I interrupt you? If I understand you, you're saying that we need to have a new rule because technology has changed how we think about snow and ice. Am I right?
That's one way of putting it. Another way of putting it is an extension of the Munsey Rule. An extension of the Munsey Rule. Munsey Rule says that a property owner should use reasonable care in maintaining his premises in a reasonably safe condition.
And aren't you saying that in modern times, property owners have mechanical devices that they can use for snow removal that they didn't have back in the old
No question about that.
days? Isn't that your position?
Our position is there were no shopping malls back in 1883. There was no automobiles. There were no 10-wheeler dump trucks. There was no sanders.
Yeah,
there was no
but there were
snow blowers.
There were horse-drawn wagons that created ruts, and we have rules, that exceptions, it's a much broader rule than you seem to let on to.
Those were the horse and buggy or horse and sleigh days. Back in those times, they wanted that ice pack on the roadway to facilitate the sliding of the sled as it moved, as it was pulled along by the horse.
Could I ask you this question? Let's assume we agree with you that the rule should be something that looks to, a standard if the property owner had reasonable notice and a time to do something about it. But let's just take your case. No question that the target parking lot was plowed and maybe sanded, and assume that the piece of ice on which your client fell resulted from runoff from the snow pile. Is it your contention that even if we had some Mounsey form of rule, that a landowner, once he plows and sands, has to sort of be constantly vigilant to make sure there isn't a piece of ice that's fallen off of where he put the snow?
I'm glad you asked that question. This is a shopping mall.
Yeah.
Liberty Tree Shopping Mall. Target is located there, and they want business to make a profit. And, in fact, they are soliciting business. And they invite people such as my client to come and do shopping at their mall. In fact, they have spots located in front of the door, close to the entrance to the door, that says, this is for handicap parking.
So is it your view that the snow should have been piled somewhere else? Is that what you're saying?
Absolutely. It should never have been stationed, piled in a 3 or 4 foot median strip whereby chunks of ice and snow would flow off the pile.
Okay, well, let's say it was piled somewhere that you would consider to be safe, and the same thing happened. Chunks of ice fell off because it was warm, and then it got cold and it refroze, and somebody was walking there and fell. Should the landowner be liable in that?
Shopping malls are large areas. I'm very familiar with equipment and machines, and I could candidly tell you they have an obligation. They've got the tools, they've got the equipment, they got the huge payloaders to load up the snow and deposit it in the far reaches of the
So should we have one
parking lot.
rule for shopping mall owners and another rule for other property owners? I mean, how do you make it, I mean, if we need a new rule, isn't it going to apply to everybody?
I'm saying to you, there should not be a new rule, but an extension of the Muncie rule, which says you have to use reasonable care
But even
to
if
make
they,
the premises reasonably safe.
but even if they move, unless they remove the snow the way the cities and towns do and take it somewhere else for disposal, which most shopping mall owners couldn't afford to do, wherever they move it, no matter how far away, it's going to melt, given our climate, and then it will freeze, and some of it, and they'd have to be out there every morning after the cold at night, chipping away at the ice that formed overnight.
If their shopping mall is small, not sufficiently large to accommodate the deposit of high volumes of snow, then they should remove it. They've got the
That's
equipment.
quite an and dump it where?
What's that?
Remove it and put it where?
They dump it in the ocean. They dump it, they can dump it in the ocean. They can dump it out in the farm fields. They can dump it in areas that the public or pedestrians have no access to. And I suggest that
Well, if we're going to require something such as, if we are going to require something such as you suggest, wouldn't that be better left to the legislature to study the policy and all the implications and
Well, this
the
is-
costs?
this is common law. Muncie rule wasn't decided by the legislature, it was decided by this court. Reasonable care is common law. And that was decided by the appellate courts and not the legislatures. Reasonable care is the basis, the foundation of tort law. And most of the tort law is by decision and not by the legislature.
I take it from what your response to Justice Cowan and Justice Botsford is the following. You are not asking to change the natural accumulation rule. What you are saying is that you look at each situation and say if it was unreasonable, negligent, to stack snow in a particular kind of way, then there's liability, regardless of whether or not it is determined that it is a natural accumulation or not a natural accumulation.
Natural accumulation versus unnatural accumulation is really a distinction without a difference. You've got snow. Where it comes from matters not.
Well, it is an
What-
it's an important difference.
What's that?
though. It strikes me it's a very important difference. I mean, are you suggesting that someone has an obligation to plow their parking lot?
If you're going to have a Target department store in a shopping mall, yes. You've got to make your premises reasonably safe for your customers and your patrons coming into to do business with you.
So your argument is no matter whether it's a natural accumulation of snow, and I'm driving into this parking lot knowing that it hasn't been plowed, that all owners have an obligation to plow places that the public might be.
To make their premises reasonably safe.
Does that apply to landlords in a does that apply to landlords in a landlord-tenant, situation, two apartment building, 3 apartment building?
I didn't get the
I'm sorry.
question.
You say if they invite the public, I think. So Target, it's there, it's inviting the public, and so it has to keep its parking lot clear, correct?
Correct.
I asked you whether that would apply in a landlord-tenant situation where the landlord was the owner of a 2-apartment or 1-apartment building and the tenant occupied the premises. And you're saying the landlord must remove the snow.
Must make his premises reasonably safe. Now, when you've got snow, there's an obligation to clear the snow, an obligation to sand, use ice melt, scrapers, using a little bit of sand and salt. Don't cost much. Just go down to the local city hall and you'll find for the taking.
Mr. Papadopoulos, isn't that in effect abrogating the natural accumulation rule that we have had?
Yes.
Okay.
Yes. And I suggest that it should be abandoned, and the reasonable care standard should be used in its stead. Reasonable care is the standard. The juries can decide. It's not a space science, the snow removal. It's common sense. We're living with it today. I want to say further that safety is this is the important crux of the matter.
Well,
Making your premises reasonably safe.
Snow is slippery. Ice is slippery. Snow is dangerous. We all know that. We all live in this environment. It's naturally caused, and we know to take precautions. So just because it's slippery doesn't mean somebody else has a reasonable duty to make it non-slippery.
If it's upon your premises, you have an obligation to make the premises reasonably safe.
To whom?
Now, who's going to decide that?
To whom? Reasonably safe to whom? So you have your residence, you own it, and your high school daughter comes home. You haven't removed the snow. Does she have a cause of action against you?
If she's lawfully on the premises, she's entitled to have reasonably safe premises upon which she can walk on.
You would not, for example, go the way of the Alaskan Supreme Court that said, at least when it comes to businesses, we will apply the Papadopoulos rule.
The Papadopoulos rule. I would strongly suggest, that safety is a very, very important subject, especially in this day and age. We're talking about health care. Just a little bit of effort. A little bit of effort.
Well, you're not asking for a little bit of effort. You're asking for the place to be plowed and then daily inspected and presumably resanded, and you're asking for complete vigilance. Snow removed. Not a little bit.
Well, if there's snow, it should be removed. If it's icy, it should be sanded.
By the city of Boston. So let's give you this hypothetical. That's what we like to do, Mr. Papadopoulos. So let's see, snow is forecast for Wednesday morning, right? I've already heard. Okay. And there's going to be a great big snowstorm, and they're not exaggerating at this time, and the snow starts to fall like crazy at about 4:30 a.m., and the city of Boston owns all of these sidewalks, and people start going to work at 6 a.m. Right? Does the city of Boston have an obligation to clear all of those sidewalks before people start walking on them?
Oh, no.
As you'd say, that's not reasonable.
In the city of Boston, in the municipality's setting, they've got an obligation too. They're not absolved of that obligation. But they have a reasonable period of time to remove that snow.
That's a jury question, you would say.
that?
You say that's a jury question.
That's a jury question. The jury, being knowledgeable about these matters, like we all are going to hear the evidence when the snow came, when there was announcement of when the snow was going to fall, how much snow was, what kind of snow. I mean, all of these factors are factors that the jury should be deciding instead of being summarily thrown out of the court because whether or not it was natural or unnatural.
Now, just to be clear, you're not saying that we should pursue a strict liability.
What's that?
Are you not saying that we should pursue a strict liability theory with regard to snow?
No, I'm not saying strict liability.
So I assume then the cost of the snow removal bears into the reasonableness of the snow removal.
That's right.
So if
and that would be an issue for the jury to decide. That's what we're really saying. And that's what the Connecticut rule says. And that's what the state of Rhode Island says. And I suggest strongly the Fuller case of Rhode Island. It's a beautiful decision.
But they don't have as much snow as we have.
Well, Maine, doesn't Maine also have that rule? And Vermont?
What's that again?
Doesn't Maine and Vermont also have that, the same Connecticut rule?
And Rhode Island rule.
I believe so.
So they have more snow. I'm making your argument. That they have more snow than we do they not?
I have to apologize because
I'm sorry,
my hearing is going.
I'm not speaking loud enough. I apologize.
But Maine does have similar weather as Massachusetts has. The defendants in their brief argue, well, Massachusetts is very unique. You know, we have all kinds of different snow and ice and whatnot. I mean, most of the states have the same kind of snow and ice, and that's... thank you very, very much.
Thank you, Mr. Papadopoulos, and thank you for paying attention to the blinking red light. Mr. Scamby?
May it please the Court. Your Honors, I think if we look at Muncie and some of the basic principles that have been reinforced in the decisions, we look at the general concept of premises liability, there's some fundamentals that have never changed and never should change, and they're in the opinion. They've been restated in many cases since then, one of which is that the law will not impose unreasonable maintenance burdens on property owners. I think that's significant here because of what the plaintiffs are urging the court to do is to abandon this natural accumulation rule and go with essentially a reasonable care standard from start to finish, meaning every case will reach a jury no matter what the allegations
No, that's
are.
not. That's not so. That just isn't so. I mean, even under other premises liabilities cases, summary judgment is not unheard of.
But in Connecticut, Your Honor, some of these decisions that were cited in the brief, in the plaintiff's brief, said whether an event has ended is a question of fact.
Well,
Whether
but that's not Mounsey.
No, and that's what I'm suggesting is that the court stay with Mounsey because Mounsey is consistent with the natural accumulation doctrine. Because not only do we not want to have unreasonable maintenance burdens, but
if you take Mounsey, would you say that Mounsey and Aylward, if I'm pronouncing that correctly, are consistent? When Aylward says, we just don't touch natural accumulation.
in that narrow respect, Your Honor, they seem inconsistent, but we look at the cases that have come down since then. And we've cited them, I think both parties, and even the amicus briefs have cited these cases. There are so many exceptions to natural accumulation. So many cases have recognized when it is not a natural accumulation.
So doesn't
and
that
therefore
suggest that
actionable.
maybe it's not a great test if we have to have so many exceptions?
Well, I would suggest, Your Honor, that what it tells us is that we have a good roadmap here. We have a good body of case law that tells us what is going to be an actionable defect and what is not. And
You really think so? I don't understand it at all.
oh, I know it's been
All of these exceptions total up to be a complete morass, it seems to me.
It seems that way, Your Honor, but when you think about just what is the underpinning of natural accumulation, and the argument I understand is that the law essentially encourages property owners to just leave the snow and ice alone.
No, well, it doesn't even do that, though, does it? If it becomes rutted and pitted as a result of pedestrian traffic or vehicular traffic, it can become an unnatural accumulation.
Absolutely.
So when does a natural accumulation of snow and ice no longer become, when is it no longer a natural accumulation?
Well, what the cases tell us is, and going back to this Court's decision in Sullivan versus Brookline, some act or failure to act of the property owner has changed the condition.
No, that's not, but with the rutted cases, the property owner did nothing. It's just that time made the rut. So.
Absolutely, and the Mansfield versus Spear case talks about the passage of time, and recently an unpublished decision from the appeals court, which is in the Matta amicus, the O'Brien case, says it reinforces that doctrine. And so the passage of time can transform it. We have conditions like the structure itself, runoff. We have potholes in parking lots. We have tire tracks or footprints. We have all these cases that talk about, or even the recent case from the appeals court in Barrasso, where we have the snowplow company building a bank in front of a dumpster.
And can you
These are all
explain to me the
cases that have-
difference between Barrasso and this case? I mean, how is one supposed to get a guiding principle out of this?
Well, if we look at Barrasso, Your Honor, it was a condominium complex where the plow company forced the snow that it was plowing up against a dumpster, and I believe it was about 3 feet high or 3 feet across in any case. The plaintiff in Barrasso wanted to get to the dumpster behind it and therefore stepped into the snowbank.
Right?
And the court there said, the appeals court said, well, that's certainly whether, at a minimum, whether that's an unnatural accumulation is a question of fact.
Well, how about an argument here? And I'm not
Well-
saying that the fact, but you have a handicap parking spaces. There's a big snow bank right there that has happened because of the plow, and you have somebody who's in a wheelchair and gets stuck on a piece of ice that's run off. Is that different?
I believe it is, Your Honor, and the reason it's different is because what we're looking at here, and Your Honor's had these questions before, is the snow accumulates and it needs to be put somewhere. Now, I know Mr. Papadopoulos thinks we can put it in the ocean, but we're accustomed to seeing in shopping malls that
I don't think my colleague Justice Spina, who lives in Pittsfield, thinks you can put it in the ocean.
Right.
Okay, so we can agree
But-
the ocean
Well,
is...
no, I think you can.
But, Your Honor, but what we look at
Well, what about the elderly person who lives in a single-family home and is expecting Meals on Wheels to deliver the food to the house? Is that person obliged?
Justice Marshall raised this question. I think it's a very important distinction that if the court's going to change the rule, it's one thing I would suggest that be considered here. Is this going to be like, I believe, Washington, which recognizes that we're going to impose this reasonable care across the board standard on commercial property owners? I think it is a very different situation with a residential property owner, not necessarily a landlord-tenant. I think that's a little bit different, but just a regular homeowner. If an elderly person is confined to their home and it's expecting Meals on Wheels, who is going to plow? Who's going to shovel the walk and shovel the steps and put the ice melt down?
But
If
what
we're
about a
going to-
healthy young person who lives in a home? Are we going to have different rules for different people?
Well, that's exactly what I'm suggesting, Your Honor, is if we go with a reasonable cash standard, we're going to have no guidance whatsoever. Because what about a
think we
person
have
who works
guidance
overnight?
now?
I understand it's an imperfect rule, Your Honor.
So
and-
why doesn't the reasonable care standard fit all? Why isn't it a rule that fits all?
Because it, for several reasons, but one of which is it doesn't give any, it gives no recognition to our climate here. It doesn't recognize.
Other states that have just even more snow seem to live with a reasonable care standard.
And I would suggest that our rule's better. Maine has more snow, we have more people, Your Honor. We have a much denser population.
Who are less hardy, so they fall more. Is that right?
Yes, but going back to Justice Botsford's question, though, what makes this case different from Barrasso? We had the description of the snow as a globber about half the size of a baseball near a snowbank. And I'm sure Your Honors can relate to this. I mean, 2 weeks ago on Monday, all that ice that had been around since around Thanksgiving melted. It got hot, or it got warm anyway. And by Thursday, it was cold and freezing again. And we see this quite frequently here.
So it's like the grape on the floor of the supermarket.
I don't think it's modus operandi. Judge.
But don't you have to examine your property at different times to make sure that it's safe and reasonable for people to visit?
Yes, but the question then becomes, is it going to cross over to an unreasonable maintenance burden? Because what we have, when we have the temperature rising, the temperature falling, we have vehicles coming in and out of parking lots. Some folks don't tend to wipe, the snow off the roof or off the hood or off the tail. The snow accumulates and the slush accumulates in the wheel wells, and they pull into parking spaces, and then they pull out and new cars pull in. Are we going to have property owners patrolling the parking lots all day long on the off chance that a piece of snow may fall off a vehicle, a piece of snow may come off of, children may be throwing snowballs in the parking lot? At some point, we have to have a rule that acknowledges that we can't overburden property owners by making them patrol their parking lots all day long.
Why is that different from Justice Spina's supermarket rule? There are people going through the produce section, the fruit section, and they're dropping all sorts of things during the course of a day. We don't speak of the natural accumulation of bananas or grapes. We speak of reasonable care, and
We
we
do.
adjust the rules accordingly.
We do, and I would think the difference, Justice Ganson, is in the Sheehan case, it was the supermarket itself that decided to put the pieces of produce out and to have the sprayers. And I think that is what went into that decision. It was almost, we can cross over into the premises liability law where the property owner actually creates the defect, or an error or omission creates the defect, or an act of omission.
So you think it would be okay for the Liberty Street Mall to remain open and permit 2 inches of snow now melted into a glaze of ice to be on all the sidewalks and on all the parking areas, as long as that is a natural accumulation of snow and ice?
I think it would be extremely unwise for the Liberty Tree Mall to do that, Justice
I'm
Ganson.
sure it would be. But are you
Because,
saying that
first
it would
reason-
not be, it would not be actionable for someone who would be going to the mall and slipping to then bring an action against them?
But Justice Ganson, I think if we look at the decisions, if we look at the cases talking about like the Phipps case and like the O'Brien case and the Mansfield case, if Liberty Tree Mall does nothing and leaves the parking lot iced over, first of all, no one's going to come there. So now the Liberty Tree Mall is going to have no business, and at least if someone does go there, there's going to be some. Let's just say someone has a 4-wheel drive truck and thinks they're going to make it through, and now we have tire tracks.
Your view is we should drop the reasonable care standard and let the market decide with regard to that a business owner who fails to use reasonable care will lose customers, and that's sufficient sanction.
Well, that was Part A, Your Honor. I think Part A is that it's not realistic to suggest that, especially in a strip mall setting here, or any type of outdoor facility, that a landowner would be wise to take no action, because first of all, we have the loss of business, but secondly, we're going to have time pass. We're going to have trucks, cars, people, foot traffic coming in there. It's going to, consistent with all these cases that have found at least a jury question, have allowed these cases to get to a jury, it does create a duty of care because it gives the unnatural accumulation that is required to get past a summary judgment motion. So I don't think that the existing rule encourages property owners to take no action whatsoever.
You cite in your brief, you cite the case of Jacobson versus Massachusetts Port Authority. And I don't have the case in front of me, but in that case, at least the way you describe it, the jury was warranted in finding that defendant had notice of a dangerous condition, a half-inch of glazed ice, on an airport terminal sidewalk, and an opportunity to correct it. Therefore, they were liable.
Yes.
Why isn't that something that we should apply more broadly? Just as it is. I mean, I don't have the case in front of me, but
I think that decision, the Jacobson case, like the O'Brien case that we mentioned before, it's in the Matta amicus, I think that those two cases still recognize the natural accumulation doctrine while permitting, on the facts, the case to go forward. The reason being is that in the Jacobson case, we had a heavily traveled sidewalk, and in the O'Brien case, we had a heavily traveled entrance to a Christmas tree shops at one of the strip malls. These are facts that have been advanced by the plaintiffs to say there's enough here to at least give a jury question on whether it's an unnatural accumulation.
Isn't that just a
parking lot's
code word?
well-traveled.
Isn't that just a code word for it's not reasonable? I mean, when natural becomes unnatural, somebody's made a judgment that this wasn't reasonable any longer, not to have done something about the snow. I mean, in other words, I know our cases make, they say after a certain point of time, it becomes unnatural. Well, I read that as really saying we recognize that after a certain amount of time, it's no longer reasonable that the landowner hasn't done something.
And I think that speaks to both the notice to the property owner. There's a reasonable amount of time now. The property owner has to or should be on notice of a condition, and presumptions, reasonable inferences that a jury could reach concerning foot traffic or any other issue. But in these two cases, a heavily traveled area by pedestrians coupled with a passage of time, is going to be enough to create a reasonable inference that the landlord's, or the property owner has had reasonable notice and has had an opportunity to correct the condition.
And
So I
that
don't
would be a
think-
jury, would it be a jury question on whether it's heavily traveled and the question of how much time has passed? Or is that a summary judgment question, a question of law?
Well, I would suggest that if there are sufficient facts raised to say that it may be disputed, the defendant may say the accident happened 5 minutes after the snow stopped, and the plaintiff may say it happened 6 hours. If there are disputed facts, certainly that would not be ripe for summary judgment.
Why isn't a parking lot outside of a Target store a heavily traveled area? I mean, isn't that what parking lots are for? Get your customers in and out?
Certainly.
Mr. Scamby, could I just add, this is the Chief speaking. It will not have passed notice that when the Supreme Judicial Court issues a request for amicus briefs on an issue that hasn't been raised by either party, something is afoot, correct?
Absolutely.
Would, assuming that we were to modify in some respect the existing jurisprudence, what view, if any, do you have to when that new rule, assuming that it takes place, should apply?
Your Honor, our position on that is that it would go against the presumption of retroactive application. There are, I'm sure, hundreds of cases pending next door in all the counties of the Commonwealth, probably upstairs in the appeals court, involving ice and snow. And property owners for over 100 years have had this rule in place. They've dealt with this rule. And if the court's inclined to change it in a material way, I would suggest that prospective application will at least give property owners the ability to
You said
plan.
that in your brief, but let me suggest that prospective has many time periods. You are suggesting prospective as of the date of alleged injury, whether a complaint has been filed, cases pending on appellate's review. What's your, I suppose you would say...
The next storm.
I think one's coming. I would
I
suggest
don't think we'll
that
have a
as-
decision out by Wednesday, but...
I would suggest that at least at the earliest, it would be the date that this court issues a decision. So
And that
But you mean
any-
date of
bar can be
injury.
notified.
You're talking about people injured thereafter would be able to raise this new standard?
Yes.
And the
Yes.
people who have not yet filed a complaint yet, but who may have been injured, at least they claim to have been injured because of the negligence, of a premises owner. Okay.
Thank you, Your Honors.
Thank you, Mr. Scamby.